Okay, so welcome to this fifth seminar. We're nearly there in international refugee law. And what we want to talk about today is what happens after people are recognized as refugees. So if we think about it, we were talking about the framework of the Refugee Convention. We talked about when Refugee Convention doesn't apply or who doesn't apply to, which is exclusion, and in certain circumstances to Palestine refugees, as we saw yesterday. We also talked about the inability of some people to access asylum because of various practices, externalization, containment, and the relevant obligations that states have in terms of reforma. And we also, of course, talked about specific circumstances such as displacement from conflict and whether the refugee convention framework is well suited for them or not. So we've had all of these different guises, but what we haven't dealt with thus far is what happens when somebody actually does manage to access asylum, has their asylum application assessed, is found to be a refugee, and then gets refugee status, not other statuses such as temporary protection, but the status as is designated under the convention. And so there are several dimensions to this question. I mean, the first is how long and under which circumstances does that status come to an end? So that's the cessation clauses. So we're actually going to start from that question because in many ways that is the mirror image question of the conditions for granting someone refugee status. So if we think about the refugee definition, we talked about the cumulative conditions for refugee status being outside one's country of nationality or residence, and having a well-founded fear of persecution for relevant convention reasons. When one of these elements no longer applies, then at least in principle, that suggests refugee status is no longer required. And depending on the circumstances, it might mean a person moves to a different status within the state, or they might be repatriated, or at least uh, the assumption would be that they might have to repatriate. Right, so that's the cessation clause, and that's why I'm actually starting there. And once we cover that bit, what I want to then delve into is the question of the rights that refugee have under refugee law, but also under human rights law, once they've been recognized. And I want to talk generally about the framework for rights protection in the Refugee Convention, which, as a way of reminder, is an early instrument, right? It's from 1951. It preceded the main human rights treaties, and as a result, the framework is looks very different than the sort of frameworks that we are used to, or those of us who are familiar with international human rights law are used to in other human rights documents. There are various contingencies both on the level of treatment and on when treatment or when rights accrue to refugees. Both of these are features that are foreign to general human rights law. And so what we want to talk about is um, how the refugee framework sits alongside human rights law. What are the interrelations between them? And then I want to zoom in, and that's where I kind of proselytize to specific work that I've been doing, to zoom in on one aspect of refugee protection, which until I've written on this hasn't at least been given, I think, the due attention it deserves, which is the political predicament that refugees find themselves in. That is the ramifications from a political perspective as an individual member of society, that refugees suffer having been recognized as refugees, but not become citizens of their country of asylum. If they have become citizens of the country of asylum, that would be one of the circumstances under which the refugee status will come to an end. So the underlying assumption they haven't, and what happens in that interim period, which, as I'll try to persuade you, can be indefinite or is indefinite, and as a result has various consequences from a rights-based perspective for what happens to that refugee as a political being, as an individual, as a political being. This is, of course, particularly, I think, um, relevant for people whose basis for asylum was a form of political persecution, but it's relevant to any person if we accept a framework where people deserve to be members at least of one political community. So that's where I'll kind of try to finish today. Before I delve into all of these elements, I want to talk just in wider terms to kind of, in a way, sum up the discussions thus far in the course about what a colleague of mine at the Refugee Study Center in Oxford has referred to as the three asylum paradigms. And I want to try and map them to some of the phenomena that we have been discussing in the course thus far. So that's enough by way of overall introduction to today. Um, and I want to then delve into first this notion of the three asylum paradigm. So, um, was Jean-François Derrier, who used to be a UN protection officer at UNHCR for many years, as I say now at the Refugee Study Center, has developed in the 2010s is an attempt to offer taxonomy or an account of the different types of asylum um, methodologies, right? So why do we grant asylum to people beyond the Refugee Convention? So one of the paradigms relate to the Refugee Convention, but what explains some of the other rationales for granting people asylum? And he came up with three types of paradigms for offering protection. In fact, I mean, I use three asylum paradigms because that is the title of his piece, which is on the reading list. But I would, if I had written this, I would have probably called it through three protection paradigms because that might be a bit less confusing because we often associate the notion of asylum specifically with the Refugee Convention. So let's think about the three protection paradigms. And within three protection paradigms, what he suggested that we can map the type of protections that we offer, or the bases for protection that we offer onto three types of paradigms. The first he calls a persecution paradigm, the second he calls an inhuman treatment paradigm, and the third he calls a disaster paradigm. And those map onto different regimes within international law, all of which we've, in one way or another, discussed in the course. So the persecution paradigm is the classic kind of 1951 convention, 1967 protocol paradigm. It's a paradigm where we identify people who are in need of protection, um, and because they're in need of protection due to persecution, we deem it to be the case that they have severed their ties, at least temporarily, although, as I say, indefinitely, with their country of origin, for no fault of their own, right? So that's the discussion we've had yesterday about exclusion. They are in need of somewhere else um, that would act instead of their state of asylum of origin, rather. So this notion of surrogate protection, but also the notion of acting what David don't blank you on his surname. I'll come back to me in a second. David Owen, of course, in Southampton, calls acting in the civic space of another country, or in Latin, in loco civitatis. And in that kind of type of paradigm where there's no fault of the person, and there is actually fault in the country from which they come, which is that it failed to protect them, right? That's the notion of serious harm being comprised of failure of state protection, and indeed the serious harm, sorry, rather the notion of persecution comprise of those two elements, failure of state protection and serious harm. In those circumstances, the needs that they have is to be admitted to a new political community. That's why also the framework that I'm going to propose later very much sits comfortably in relation to voting rights or political rights more generally, sits comfortably with this persecution paradigm because it's a condition by which the individual no longer maintains the sort of connection that we expect, at least in an idealized form, individuals to have to their country of origin. And as a result, he calls what happens in those circumstances the grant of status as a refugee, with all the trimmings that come with it, is a form of a privileged alien status, right? It's privileged in several dimensions. One is that it's intended to be one once granted that can only come to an end if the persecution grounds have come to an end, right? So that's the cessation clauses we will come to. So it's not discretionary, and it's not fixed term in the ordinary sense of various alien visas or migrant visas. It's different than a student visa or a temporary migrant worker visa. It's in his words a form of a privileged status. Again, I'm presenting his model. We can contest whether those are the best terms to be using, but that's the first kind of classic paradigm. And the second paradigm is a paradigm that we see very much through principles of non-refoulement in human rights law. And we talked about this in the seminar on non-refoulement, where we said, whereas in the Refugee Convention, states have a qualified obligation of non-refoulement because there might be circumstances where they would be deemed eligible to send someone back to danger if that person poses a threat to the country itself. So even though they would suffer persecution somewhere else, or indeed we know this from the exclusion clause last class, right? That somebody may have a persecution concern or need for protection, but they still are people who we deem under the Refugee Convention not to be deserving of protection. And so, under the persecution paradigms, they fall by the wayside. The inhuman treatment paradigm isn't focused on, and under Jean-Francois's framework, isn't focused on what will happen to the individual from the point of view of the individual, but rather is focused on what will happen to the individual from the point of view of the state that grants them protection. In other words, the framework here is that we, as a state of asylum, do not want to be complicit in sending someone back to risks of harm, such as torture, such as the death penalty, such as indiscriminate violence, irrespective of whether the person is one with whom we feel a sense of affinity, whether we have compassion towards them. As we said yesterday, there might be people who committed a very serious crime in another country. As a result, they are being excluded from refugee status under the ordinary paradigm, the persecution paradigm. But it's nevertheless the case that we are uncomfortable, deeply uncomfortable with sending them back to be tortured or to face the death penalty. And so we give them protection as a form of non-return to danger, but it's not derived from a desire to perceive them to be worthy of protection. Rather, it's a desire not to be complicit in violations of rights. And it's a different framework, and as a result, it may translate to a more precarious status. It may be subject to a more frequent review, for instance, of whether there's still need to keep that person protected. It may also, as we've discussed yesterday, come with an obligation on the state from its own perspective to take defensive measures, right? It might be that they actually need to prosecute that person for the crime that they've committed, if that hasn't happened before. It might be that they need to impose various security measures to protect people in the state from that person. But the core element here is that they are granting protection to that person, not because necessarily they deserve it, but because of the harm that will be caused to them or would be meted on them by their state of origin if they were to be returned, right? So that's a different paradigm. Of course, there are circumstances where both the first and the second paradigm apply to the same case, right? So we might have someone who will suffer very serious persecution, so they would be protected under human rights law also from being returned. But if they can get refugee status, and to take you back to what I said, I think in the third seminar, or second, there is primacy of refugee law, right? So there's primacy of the Refugee Convention over other forms of protection. So if somebody meets the refugee definition, they should get the refugee status that they deserve because precisely of the message that sends to that person, but also to the state of asylum internally, right? The idea that this is someone who is deemed to be deserving of protection because of the persecution they may suffer, and because they haven't done anything faulty that would cause us not to feel affinity or compassion towards them, right? So that's the second paradigm. The third paradigm is what Jean-Francois calls the disaster paradigm, which very much corresponds um, to practices of temporary protection. And the image he has here in mind, which I think is a suitable image, right, is of someone drowning in the middle of the sea, right? And you are on the coast. At the point at which you're putting that person out of the water, the question how they ended up there, what did they do before, did someone throw them there? Those questions are not relevant, right? So the only question that's relevant is that you have the capacity to rescue that person. They are in grave danger. Then you're extending protection to that person under a form of a Good Samaritan type rescue uh, paradigm, right? So this often happens in mass influx situations, right? Those are often conflict situations, but they might be others. There might be um, in certain circumstances, temporary protection can extend beyond kind of classic refugee situations, right? They can extend to a big natural disaster where people have to flee, say, a tsunami or something else to a neighboring country. That country would open its borders and would just let people in without checking their individual circumstances. Um, as a mass influx, as a large number of people coming in a short space of time, um, under this notion of being a good Samaritan, right? This notion of coming to the rescue of someone else when they need that protection. The key element here is on the temporariness, right? So often you would rescue someone, and then when the danger subsides, so let's imagine, as I say, a natural disaster is the easiest circumstance to think about is like an earthquake, as I say, or a flood or something. When that changes, then you no longer feel a need to protect, right? So your extension of protection having been unconditional, essentially you haven't checked their individual circumstances, you just opened your border and allowed people in, also comes with a qualification, which is that you don't perceive yourself to be bound to protect that person long term. It might be that you've let in large numbers of people, and it turns out once that danger has subsided on a collective level, that some of those individuals need protection on an individual level. That's again like what might happen with Ukrainians, as we've discussed a few seminars ago. If temporary protection ends because the war in Ukraine ends, the news from this morning suggests that's very, very far from that about to happen with further bombings in Kiev, etc. But at the point where that might happen, um, then it might be that you really bring temporary protection as a regime to an end, but you still will be back in a paradigm where some individuals might need uh, protection under the ordinary, as it were, persecution paradigm, right? And some people might need protection under the second paradigm because, for instance, they've been involved in war crimes or what have you, but they still can't be returned. So the third paradigm, in a way, is a stopgap, right? It really is temporary in the substantive sense of the term, It's intended to operate in order to protect people in large numbers, in short spaces of time, when you don't have the capacity or even the desire necessary to undertake individual assessment. What you have is a situation where it's very clear a group of people need to be rescued from somewhere else, and you have the capacity to rescue them, and so you offer them protection, right? And the interesting thing I think about the way Jean-François kind of does this taxonomy is that I think it corresponds also intuitively to perhaps maybe not for everyone, but for me to how we think about the need for protection translating into obligations towards the person you've just protected. Because there is a degree of hierarchy that you can perhaps discern from this assessment where someone who has suffered in their own country on an individual level, right? On a differential, discriminatory level, persecution, or is deemed to be likely to suffer persecution given the forward-looking nature of protection, and has done nothing to deserve that treatment, and has done nothing else that is objectionable. There's really a sense, I think, and that's the core element of the Refugee Convention, that there's been a failure of the international system of states in relation to this person, right? So if we accept the world's divided into states, states have primary responsibility towards the people who are its citizens and or permanent residents, and the state has failed that person, and somebody else steps in and provides them the sort of protection that you would expect their own state to provide. And that is very different than those two other paradigms. And so it merits to some extent the different protection framework that the Refugee Convention offers compared to other frameworks that have been developed over the years in human rights law, in regional protection, to address those additional grounds that the two other paradigms speak to. So I thought that was a good way, in a way, of concluding some of the discussions in the previous seminars as to why it is that we grant people protection under the existing mechanisms, right? As I said at the end, if we see we're not exhausted and we have time at the end of today, which are two far from obvious conditions to be met, but if we get to that point, we might want to discuss some wider frameworks of people around the world who might need protection, who don't fall into in any of these three paradigms. But we still think perhaps existing frameworks fail them, right? And don't offer them protection, and whether there are ways in which that can be rectified, whether it's realistic for that to be rectified, whether it's desirable for that to change, right? So we might come to that, particularly issues around, as I say, climate change and poverty come to mind in that context. I'm leaving that to later in case we're in the space to do that. Questions on this or comments on this kind of set of paradigms? Do they resonate with people? Do they does the boundary between them make sense?
No, I
Any,
mean, yeah,
any yeah, go ahead.
I mean, it's interesting. I mean, just to think um, why the system fails just to only when the state is itself prosecutes the citizen. Why doesn't it fail when it can't protect the citizen, or just
Sure.
generally? I mean, usually states don't feel like they have any obligation toward the people of other states, whatever situation they're in. Only when it feels more than, as to me, less than care for this private citizen, as important as it is, and more as a condemnation to the state. It's here, we
Mm,
take your people, because you are so bad, we condemn you, and we also express it by the act of taking your citizen and give them the care and rights that you refuse to,
Yeah.
Be- because we
Well,
don't care if I mean a lot of sense for the
yeah. That's an absolutely fair point, and I think the two are not contradictory, right? So I mean, my own view, which some other people in the refugee sphere disagree with, is that there is a degree of condemnation, like you say, built into refugee protection under the Refugee Convention, not necessarily under the other paradigms. And that it very much is the case that when the other state, right, the state of origin, is the reason for persecution, right? So rather than a case where it's unable or unwilling to protect, but a case where it persecutes itself by um, going after political dissidents or by limiting freedom of religion or by persecuting sexual minorities or what have you, then absolutely there is an element of condemnation in granting someone from that state protection. Whether that's the whole story, I think that's part of the question. But the fact that there is condemnation there, at least I agree with you that exists. And to me, as I don't want to preempt the whole discussion later, but to me, that condemnation comes with quote unquote a price, in the sense that the state of asylum has to put its money or its rights where its mouth is, right? So if you are going to condemn another state for failing to provide someone with the full suite of rights that you expect states to provide individuals, then it follows that you have to step in fully and not only partially. And that's partly why, I come up with my framework around political rights. Um, yeah, I think you certainly say there's a chapter that I think is on the reading list, that I recommend reading. I broadly agree with what he says, by Matthew Price, that essentially makes the case that refugee status is first and foremost about condemnation. To say, I
Mhm.
think not everybody agrees. So, in the refugee community, and certainly people wouldn't agree that that's necessarily the case when the state is too weak to protect you, say, from harm by certain non-state actors. Some people would say it's wrong particularly for global North countries to be condemning weak global South countries for the fact that they're unable to fully realize their obligations because of something that is a
Yeah,
long-term challenge for those countries. Let's say it's not actually my own view is very much aligned with Price, but I think it's fair to present the alternative view here.
yeah, I think it's interesting. I'll definitely read it, but I also think that condemnation doesn't have to be necessarily for the state, because there is a reason why the big actors are also. I mean, we give protection to people that are prosecuted by big actors. So, if, for example, I give refugee status for people who are running away from ISIS, then I condemn ISIS. It's the big powerful organization, definitely
Sure.
how it was in the 2014 or something. And it's different than to condemn, let's say, just a random serial killer who kills just a few people and doesn't really control much. And from him, if the state even try to help, we don't give refugee status, even for someone who's trying to run away and is a grave danger from
Yeah.
him.
Yeah, but I think so in a sense the way to think about it perhaps is that you're condemning the circumstances that
Yeah.
have prompted their need to be protected, and you ultimately it's passing judgment on whether someone should be in such circumstances, and ultimately it's an argument that no one should be subjected to these sorts of circumstances at no fault of their own. And so when those are the cases, if the state is itself the reason, then all the more so. But even if the state isn't, if it's too weak to protect that person, the reality is that they need protection somewhere else, right? And that's
Yeah.
the idea. That was the big move that I've described, I think, in the second seminar, to accept that it's not just states that can persecute people; it can also be powerful, as you say, non-state actors. Certainly, when those non-state actors control parts of the state, like Islamic State did, but also when those non-state actors are just pervasive in society and powerful in society, like in certain instances of gang violence um, or uh, or when you've got certain areas where there's criminality, right? And the state is finding itself unable to address them in a satisfactory way. Okay, great. So unless anyone has any more questions on this, I think what we might do a 5 minute break. I'm just conscious that I don't want to do what ended up happening yesterday, which is that we went kind of continuously for an hour and a half. So I'm thinking methodologically, it might be, even though we haven't gone for very long, might be good to have a 5 minute break now, just to for people to get up wherever you, and then we'll resume at 10 past, and we'll start talking about cessation. And what we'll probably do is talk about cessation up to the big break, at the midpoint, and then after that big break. We'll talk about refugee rights and this specific political predicament because those two questions really speak to one another. So I'll see you. I'll just stop the recording. I'll see you in 5 minutes, just to give people a chance to move a bit.
Yeah, sure.
Right. Okay. So let's now talk about cessation of status, right? And let me just reshare my screen. There we go. Great. So, unsurprisingly, the structure here would be I want to talk generally about sedation and then talk about the different types of cessation clauses and about some general criteria for the application of these clauses. So, this is the provision, right? So, again, we're going to go into um, each one of these categories in turn. But there's one classification that I want to make already, right? So we think about the text of this provision. It says the convention shall cease to apply, right? Shall cease to apply. So it's not a discretionary thing, at least in theory. It's a mandatory thing, right? It's a factual in the same way refugee status declaratory. Arguably, cessation has a similar declaratory feature, right? Because of being the mirror image of refugee status itself. And it says the convention shall cease to apply to any person under the terms of Section A. So the people who are refugees within the meaning of the definition, if one of the following six conditions applies, right? And there's a closed list of six conditions, right? Which are, of course, alternative and not cumulative. So you don't need more than one to apply, because they are in different ways, all correspond to one of the elements of the refugee definition. So you don't need um, all of the refugee definition to cease to apply for refugee status to cease to apply. It's sufficient that one element of the puzzle kind of falls out and the puzzle's kind of incomplete. There's one, as I say, classification that I already want you to pay attention to, which is the difference between these four conditions that you see on your screen. So somebody's voluntarily reavails himself of the protection of their country, having lost nationality, voluntarily reacquire it, having acquired a new nationality, or having voluntarily reestablished themselves in the country. Right, that's one set of conditions. The second set of conditions is when the person is no longer able to refuse to continue, to refuse rather to avail themselves of the protection of their country of origin because the circumstances in that country have ceased to exist, right? And that applies whether under subsection C5, if somebody had a nationality, if somebody didn't have a nationality, if they were stateless, it refers to their country where they were ordinarily resident. And the distinction between the so maybe I'll ask you what just from reading these provisions, why do you think I think why do you think I think that there is a difference between the first four categories and these two categories? So I'll just put back the other four categories so that you can have a think about this. So the other four categories were the person voluntarily reavailed themselves, reacquired nationality, acquired a new nationality, or voluntarily reestablished themselves. So that's one set. And then the second set is the conditions in the country have changed. What's a relevant distinction between these two types of categories?
The first one is a person actively
Hmm.
choosing to change his state, uh, and the next two are changes circumstances that are outside of the individual decision.
Mm, exactly, exactly, right. So, and to some extent, the latter bit, right? So, the more challenging types of cessation clauses are these two that you see now on your screen, precisely because they don't pertain to individual behavior. They lend themselves often to a decision that would apply across the piece to large numbers of people because they are essentially a change, if we think about the refugee definition, in the well-foundedness of the fear of persecution for one of the convention rounds. So it's a fundamental change somewhere else that the refugee had nothing to do with, right? But that may mean that they no longer have a well-founded fear of persecution. As Avital says, the first four all relate to something that the refugees themselves have done since they became or since they were recognized rather than as refugees that suggests that they no longer have a protection gap, right? So they all relate to that protection gap, or that suggests that they're no longer outside the country, right? Which is the fourth condition, right? So the first thing to say is, as I said, these are all alternative. So the state, um, as it monitors events, may come to a decision that the state of asylum, that is, that it needs to activate, quote unquote, the cessation clauses under Articles 1C5 or 6. It may also be the case that it comes to the state's attention that somebody has done something that falls into one, two, or four, right? Those are things that didn't happen ordinarily in the state of asylum itself, right? It would be things related to their country of origin. Or it, of course, would know if it offered someone nationality and they accepted it, right? So if a state of asylum offered the refugee to naturalize and the refugee decided to naturalize, then of course that would alter their status under Article 1C3. So there's a deeper question, which we would come to towards the end of the discussion around cessation clauses, as to how proactive states should be in trying to find out whether people still need protection. In other words, how often, how robust should their assessment be? Once they've granted somebody refugee status, given that the default position, which is also a point I'll come back to after the break when we talk about rights, the default position is that once somebody has protection, then they retain refugee protection, right? That they don't lose that protection unless one of these cessation clauses applies. So this is a closed list because refugee status, because of its declaratory nature, needs to remain, right? So if somebody is a refugee within the meaning of Article 182, unless something changes that no longer makes them a refugee within that the meaning of that definition, then they need to continue to be recognized as a refugee, right? So that's the default position. Um, but that default position may change. And the question is, how the state assesses that change. So what I would want us to do is we'll go through each of these subsections, and then we'll ask some more general questions about the way in which states go about assessing whether somebody still needs protection or whether their protection can cease under this framework in the Refugee Convention. An element that I left off the slide earlier is this final component that doesn't relate to the individual actions, right? But relates to things that happen in the state of origin that do not pertain to the individual, right? And that's a provision that was added, and I'd be again interested to see if you can pick up why that provision was originally added. But the provision that was added, the qualifications that was added to these last two cessation clauses, so situations where there's been a change external to the individual in a country of origin, says that these provisions, 5 and 6, shall not apply to a refugee who is able to invoke compelling reasons arising out of previous persecution for refusing to return to the country. So, why do you think, knowing the history of the Refugee Convention, what is the type of case that the drafters here had in mind of a potential return because of a fundamental change of circumstances, where the individuals who would be potentially forced to return would have compelling reasons to refuse to do so that arise of their previous persecution? Any any thoughts thinking about the context of the Refugee Convention? So remember again, the context is that refugee status is forward-looking, right? So the question in refugee law is what will happen to the individual if I were to return them? But often people will have suffered persecution already, right? So that may cause them to be very queasy about returning to their country of origin. That isn't decisive necessarily, because what they need is to have compelling reasons. Of course, we don't know because the convention doesn't tell us what qualifies as compelling reason, what doesn't. But that is the benchmark that is being applied. So, which group of people did this originally, or did the drafters originally had in mind? Last attempt. Okay, so the image the drafters had in mind was of demanding that Jews who fled, say, Nazi Germany, would have to return to the post-war Germany immediately after the war because, so of course, this is the convention was written a few years later, but that's the sort of prototype they had in mind. They'd say somebody had suffered serious persecution in their country, they fled it. Now there's been regime change, but they still know, right? As we know, many people for that reason, for a long time, would not go to Germany from who had a history of persecution. They would know that a lot of people walking around the street around them in the various contexts of their social life will have participated actively in persecution, and so they wouldn't want to do that, even though there is no longer a protection need, right? So it's no longer the case that if they were to return, they would suffer persecution. That's the assumption under 1C5 and 6. But you would still, the state of asylum should still not force them to return under those conditions. So that was the image people or the convention had in mind. That's why they set a standard of compelling reasons, right? Whether states tend to apply this. So of course, states have to first want to apply the cessation itself, and then do they engage in this assessment and um, end up absorbing, as it were, individuals from having to return on these grounds. I don't have the statistics on this, so I don't know how to answer this question. But it is conceivable, and you can think about modern examples of people who are living under a very oppressive regime in situations where large parts of the population in that state, even if not a majority, were complicit in the operation of that regime, and they really genuinely do not want to return under those conditions. And there's a question as to whether they should be forced to return, right? So that is ultimately the legal question that follows from cessation. And because the cessation clauses are mandatory, right? So because the convention says, or the provision says, the convention shall cease to apply. That's why this proviso had to be entered. And it was entered in relation to 1C5 and 6 for the reasons that I've asked you about earlier, as Evyatar noted, because of the distinction between the first four iterations in this provision where an individual has actively done something, right? Where we can assume that that individual is willing, or we make an assumption, a rebuttable assumption, they're willing to return and live in their country. And 1C5 and 6, where the individual's done nothing, right? The circumstances have changed, but they may still have a strong grievance towards the place they originate from, and that grievance may be justifiable in stopping cessation from happening, right? So that's the context of this additional provision in Article 1C, 5, and 6. Any questions on the overall framework? If there are none, then let's start going through the six individual or the five categories because we'll treat five and six together. So the first one is a case where somebody has voluntarily avails themselves or re-avails themselves of the protection of their country. And that's um, often can come into play when people approach the embassy or consulate of their country and ask that it provides them with active protection, right? For instance, that they get a new passport issued rather of their country of origin, right? Because once somebody is a refugee, the expectation is that they would not travel back to their country of origin. And so if they were to travel anywhere else, as we'll see a bit later today, they're supposed to use a different travel document, which is one that is issued by their state of asylum. So if somebody had their passport, say somebody is um, an Afghani woman, right? And um, she gets refugee status in the United Kingdom, and her passport expires, and she goes to the Afghani embassies and wants a new passport, right? If you open your passport, it says that this passport, that the state issuing this passport asks other states to respect that individual, their holder, and essentially grants them a form of protection. Fundamentally, it's a protection, as we've discussed in one of the seminars, that if that state wants to send them back, there will be somewhere they can send them back to because there's somewhere that has to accept them because they possess a passport of that state. So if somebody of their own volition, right, actively goes to an embassy or consulate and seeks to renew their documentation, that often would be perceived as re-availing oneself of protection. More obvious examples is if somebody really seeks diplomatic protection, right? So if somebody has been treated badly in another country, in a third country, say you've got a refugee from Sudan who's in Germany, they travel to France, something happens to them there, and they turn to the Sudanese embassy for protection rather than to the German embassy, right? That would be seen as a demonstration that that's a country to which they still maintain ties that are relevant and which they wish to exercise, right? So that would be the sort of circumstances. And the condition here, which is critical, of course, is that you need to be acting voluntarily. You need to intend to seek protection, and indeed, you need to also actually receive it, right? So even if it is the case that somebody is willing now to re-engage with their country, and if that country simply will not cooperate, right? They will not issue them with a passport. Then you can't say that person has re-availed themselves of protection because, as a matter of fact, they do not have the protection of their country, right? So you need to want to have that protection, and you need to be able to get that protection for this clause to apply. And there's a similarity between
Yeah,
this provision. So go ahead, yeah,
I have a question.
yeah,
But what about a situation when a refugee goes through the process, say, asks for a passport and even receives one and everything, but
yeah.
he does it based on a mistake that he won't be prosecuted when in fact he will. Uh, so I didn't see any mention of it the articles you we saw here. So does it address
What do you
situation?
mean by what do you mean by mistake? I mean, ultimately, for the refugee to remain a refugee, they need to persuade a decision maker that they have a well-founded fear of persecution. If they go to an embassy of their country of origin and want to get a passport because they no longer think they would be persecuted, then they have no fear of persecution. Then that element of the refugee definition falls out,
Hmm. No, but
right? So
say
because
I'm
it's
a
not
say I'm
because
a
it's not just an objective test, right? It's also a subjective test. The person who seeks protection needs to fear the persecution that they would be suffering, right? So
yeah.
uh, that's an
But no,
indication.
but say I'm a refugee.
Yeah.
Say I fled because I was persecuted for my political beliefs, and I saw an article that
Mm,
says that the regime now changed its mind. It's
sure.
no longer prosecuting people with beliefs such as mine. So I go to the embassy, I ask for a passport, but
Yeah.
in fact, this article was based on a lie or
Okay.
misunderstanding. So right now, the country that hosts me says, "Well, you asked for a passport, you need to leave." So do I say do do the fact that I was wrong automatically cancel it, or do I need to go to the whole process again, like I'm a new
Sure.
asylum
Well,
seeker that just entered the country right now?
sure. Well, look. So there's no obvious answer to this from the text, right? So ultimately, going to your country of origin's embassy and asking for a passport to be reissued creates a presumption of protection, right? So it creates a presumption that the person no longer has a well-founded fear of persecution. It's rebuttable, right? So if the state of asylum finds out and then wishes to activate cessation, then depending on its administrative procedures, there might be an opportunity to appeal that decision, and at that point you might say, no, that was a mistake. It was a good faith mistake. I'm not intending to use this passport. They might again, it depends because there isn't an answer in refugee law to how you administratively deal with this. But I don't know, a state of asylum might say, okay, fair enough, then surrender the passport that you've just received because you won't use it, so you don't need it, right? So that's an indication that you made a mistake, then why would you carry that passport? So that might be, if I were a decision maker, I might say that's a reasonable demand, right, of that person to say, if you've acted by mistake, then you essentially reverse that decision by not keeping the passport, right? So yeah, I don't think ordinarily, I don't think you would restart the application. It would be a case of whether your current status still needs to remain or not. And that's ultimately the assessment the state has to undertake. Does that make
Yeah,
sense? Yeah,
yeah.
perfect.
Thank you.
Cool. Okay, so very similarly, 1C2 deals with refugees who lost their nationality, right? So some countries, famously or infamously, the Soviet Union used to do this. It would consider anyone who left as a political dissident or even left just to move, for instance, to make Aliyah or move to Israel or to move elsewhere. They treated them as having betrayed the Soviet nation, and as a result would revoke their nationality. And it doesn't always happen, right? Which is why most refugees are not stateless persons, right? So the two categories of refugees and stateless persons don't overlap. There's a partial overlap, but they don't fully overlap. There are some refugees who are stateless, there are some stateless persons who are refugees, but there are stateless persons who are not refugees, and there are refugees who are not stateless, right? So this cessation clause deals with refugees who were not stateless in the first instance, but became stateless pursuant to a decision of their country of origin after they have left that country, right, and sought asylum elsewhere. That, as I say, used to be the practice, remains the practice in certain dictatorships, that you would lose the citizenship. And so imagine in that scenario where there's a new regime in that country, or even the old regime decides, has a change of heart, and decides to reinstate the passport or the nationality, right? So it offers that individual a to reinstate the nationality, and the individual accepts, right? The individual says, um, "I will take that nationality again," knowing that they have previously lost it, right? That is deemed to be and as the slide says, the loss can happen before, after they're recognized as a refugee. Again, the emphasis here is on the voluntariness of the action, right? So if a refugee voluntarily regains a lost nationality, we assume that they accept their country of origin's protection. Otherwise, why would they do that, right? Why would they do it at that point in time when they are refugees? Um, However, and this is important, if a refugee's nationality is automatically restored by law, so if something has changed automatically by law, but there was no approach to the individual that prompted him or her to make an individual decision to take that nationality again, then that shouldn't trigger cessation, right? So there might be a case that there was a law of general application that any person leaving the state without authorization loses their nationality, and that law gets repealed. And then automatically everyone was left without authorization gets their nationality back. The individual has had no interaction in that instance, so they shouldn't be penalized, as you were, or detrimentally affected by that scenario. If the refugee has a choice to reject that nationality, but they do not act, then they may be considered to have voluntarily reacquired nationality. So, for instance, if the country of origin would contact you and say, "We want to offer you nationality. If you do not want it, please let us know." And the refugee doesn't, then they regain nationality in conditions where they had a choice, right? And they choose to do it. And it's then deemed to create a presumption, again, a rebuttable presumption, that they no longer need protection from the state of asylum because they now regain the protection of their state of origin, right? So that's the second kind of, as I say, 1C1 and 2 have a lot in common. 1C3 is usually, although not always, related to actions the individual takes vis-a-vis their state of asylum, right? Usually, I say, and not always, because you could have a scenario where somebody gets refugee status, and particularly in a space like the European Union, say they marry someone from a different European Union country, and they get nationality of that other country through marriage, right? That can happen. Or other things might happen that would trigger nationality. But ordinarily, 1C3 would be a provision that would apply to someone who gains another nationality because of the state of asylum offering them nationality of that state and them accepting that nationality, right? So the key kind of components here is that the person must be legally recognized as a national under that country's laws and administrative practices. And the issue is whether the individual genuinely benefits from the protection of the new country. And arguably, there are two conditions that need to be met for that. The first is the nationality must be effective. So there needs to be a connection between the individual and the state. So, for instance, it could be the case that they get it automatically another nationality because of marriage, but they have no connection to that other country. Um, or at the very least, it's not obvious that they have a connection to that other country, then you need to assess whether they do. And you need to assess whether they must be both able and willing to seek protection from that new country. Let's imagine the person who they married has two nationalities, and one of those countries grants nationality automatically based on marriage to your spouse. But that country is a country to which that person that they married has no effective connection. They've never been there. They don't speak the language. They don't hold a passport. Um, it's a country which itself is not particularly stable. Um, and so the question whether on the ground that the refugee now has that nationality nominally, whether that should lead to cessation is more contested, right? It's a factual question that needs to be determined. When it's the state of asylum itself that granted the refugee its nationality, then it's almost inevitable that the state would consider its own nationality to be effective, having just granted it. And that ultimately nationality is a gold standard, right? Nationality is a better status than refugee status because it's permanent, or at least it's supposed to be permanent. It comes with the full suite of rights, it comes with full protection. And so no one would really need to hold refugee status if they have become a national of the same state. That would be inconsistent in a way with the notion of what it means to be a refugee. And so that's the classic scenario, right? Where states offer nationality. As we'll see after the break, states don't have to offer their nationality under international law, and many don't, right? And many don't for a long period of time, creating that political limbo that I will try and persuade you requires specific treatment for refugees. So that's Article 1C3. 1C4 is the last of these situations where something has happened related to the specific individual, and that is when the individual has voluntarily reestablished themselves in the country of origin, right? So again, the emphasis here is on voluntary reestablishment. So of course, you can't force someone to return and then say, you're now outside, you're now no longer outside your country of origin, then we revoke your refugee status. So you can't deport somebody to that country. I mean, that would, of course, also breach non-refoulement, and then use that basis to deny the refugee status. That the person had to go voluntarily, and they had to stay in a way that is safe for them, right? So they need to not have been subsequently imprisoned or otherwise mistreated. And the question is, what does the term reestablishment mean? What does it mean to say someone has reestablished themselves in a country? For instance, does a temporary short visit count as reestablishment? UNHCR would say a long stay suggests reestablishment. A short stay may also be a form of reestablishment if the person managed in that short space of time to live normally, to work, to be paid in a way that indicates that they have resumed their lives in that country. But if somebody, and this is a practice that has happened particularly in sub-Saharan African countries, where somebody from the family, often younger, more able-bodied people, would would cross the border, would seek protection, would get protection, but the rest of the family has remained in the country of origin, and they want to go for a weekend or have you to just check on them to see that they're okay, maybe to help in their preparations of fleeing as well, right? Because it might not have been possible for everyone to flee at the same time. So there is an argument that even though nominally, for the short period of time that person has returned, they are no longer outside their country. And so that condition of the refugee definition falls. We should think about it from a purposive perspective. We should think about the reason that person returned, whether they indeed still have a well-founded fear of persecution in relation to that country. Hence, their return is short term. Often, we would suggest that if they returned in a legal way, so if they travel with a proper travel document that relates to their country of origin, because the country of asylum ordinarily would issue them travel documents that are not valid for travel to the country of origin for that reason. So if they instead use an existing and non-expired passport of their country of origin and they go through a formal border crossing, we might say in those conditions that is a form of re-establishment. However, if you've got someone from Sudan who crossed into um, Kenya, or you've got somebody from the DRC who crossed into Uganda, and they have still family across the border, and they just cross the border in a irregular way with smugglers back to check on the family and return, and you find out that they have done that. Arguably, that shouldn't be in itself a basis for revoking or seizing the refugee status. The assumption here, of course, being that they will have, after that short visit, returned to their country of asylum and that they continue to claim that they have protection needs, right? So that is the assumption. These are complicated circumstances, right? And a complicated provision to apply. Um, because sometimes people do find themselves in a position where having fled, they need to go back temporarily and they don't want the refugee status to go away. I mean, interestingly, I've given the example when we talked about not subsidiary, about temporary protection, that with Ukrainians, the European Union's temporary protection directive allows effectively Ukrainians to return to cross the border, to go to Ukraine, and then come back and not lose their temporary protection, right? So, because of almost a realization that people would have to do this, I mean, Ukraine also has these peculiar circumstances which are contested, at least to say the least, where young, and not even just young, but males essentially from a certain age are not allowed to leave Ukraine as a general matter, of course. And so, because of a worry that there won't be enough people to fight in the war, and so usually the people who have left Ukraine would be women and children who have crossed to European countries. They may want to go and see their spouse or their father, etc. And the European Union acknowledged this, I think, by saying that would not trigger cessation or the equivalent cessation given it was done through temporary protection. So 1C4 is a complicated provision because it triggers, in a way, the challenge around the person having to be outside their country, but at the same time, the realization that in real life, sometimes people do need to be able to cross a border temporarily. Um, and of course, the other thing that may happen is somebody may have crossed the border. They may have reestablished themselves temporarily in their country of origin, which would lead to them being essentially required, or the state finding itself in a position where it needs to seize their status. But then a new ground emerges, right? So you can think about the history of a country like South Sudan, right? So which originally was part of Sudan, and there were people who were returned to South Sudan or have returned to South Sudan, and then a new conflict emerges, right, or new challenges emerge that trigger a new claim for refugee status. That, of course, would, I mean, to relate to the question Avitar asked about 1C1, that you can say is a general point, right? So, of course, if there are new grounds for refugee protection, then those grounds have to be assessed on their own merit. But it may be the case that 1C4 applies to that person in the first instance. So that's 1C4. So I want to move now to the, as
Yeah.
I said, sorry, go ahead.
Okay. Can I ask a question?
Sure.
About the idea of the other country that you can get into. So I didn't fully understand what exactly the conditions that can help someone move to that makes the say the other country that gives you citizenship more suitable. Let's say, for example, that someone is seek asylum in France,
Yeah,
and but he speaks English well.
sure,
He loves and he's following American politics, and he's like football, and he for some reason or another maybe marries an American or anything like that, he can get a citizenship in the United States. So
sure.
can we say to him, well, you seem like you fit better in America than in France, so we get you out, even if you don't necessarily want to?
Well, it's not a question of whether you fit better, right? It's a question is, can we say that if they through marriage say uh, are able to apply, say, so the easier case, or the more, sorry, the easier case to kind of see how 1C3 would apply is say they don't get American citizenship automatically by marriage, but they can apply to get it. And say they choose to apply for it, and then they get it, then you might say, yeah, well, that person now has an effective other nationality of a country that is non-persecutory. And so the gold standard in refugee law is that if there is another effective nationality that a person has that is non-persecutory, then that trumps, to coin a phrase, their refugee status and means the refugee status. Because if that had been the case in the first instance, right? So remember our discussion of multiple nationalities. If at the time a person applies for asylum, they are persecuted in one of their countries of nationality, but they have another effective nationality where they wouldn't be persecuted, then the state of asylum can say the primary obligation to protect someone in that position falls on their other country of nationality, not on me, right? Even if that
Mm,
person has already been recognized. I think, as I said,
okay.
the more complicated scenarios are when that process happens automatically rather than through an application, right? So you automatically become a citizen of another
Yeah,
country.
that's what I'm talking about.
Yeah. So, I mean, I think it depends on the circumstances, right? So it's you might say if the if the ramifications of having been automatically granted citizenship somewhere else is that you are eligible from that point onwards to move to that country and live there and if that country is a country that can offer effective protection without persecution, because you can think about a scenario, let's say, again, take examples around sexual orientation, that you marry someone who's from a country that also persecutes people who are gay, right? You flee a country where you're persecuted, you get protection in a country where you're not persecuted, and then you marry in that country someone from a third country where you could be persecuted, right? So, on the basis of now having that additional nationality, you shouldn't lose your refugee status because that country would not be able to give you effective protection because you'd be persecuted in that country, right? So it's contextual, right? It depends. It's as a result much more likely to be the case that 1C3 would apply either if you get the citizenship of the country of nationality, sorry, of the country of asylum, because that's the most obvious case, or if you had to do something actively in situations like marriage or otherwise to get another nationality, and you opted to do this, right? When things happen automatically, they're suspicious because you need to assess the circumstances contextually and see whether there's really effective protection, right? So that's the
But if I marry someone, does it count as doing something active to move to another country? I mean, I
well, not
think
well,
of
not
but
necessarily
many reasons to marry someone and even doesn't
exactly.
even want to live in his or her country.
Well, exactly, but that's the point I'm making. That the
Ah,
fact
okay. Ah, okay.
that the fact that you married, that you are from Uganda and you now live in France, and you meet someone who's from Senegal, and you marry them, and you are eligible automatically to Senegalese nationality. It doesn't help you in the sense that Senegal is also a place where there's persecution on grounds, say, of your sexuality, and so you shouldn't be expected to then move to Senegal under those conditions, right? Even though you're now married to a Senegalese, right? So that is precisely the point, right? That it shouldn't be automatic. It's a question of whether that country can offer you both effective nationality and effective protection, right? So those two have to both be present. So let me talk about 1C5 and 6, as I say. And that's a situation where there has been a fundamental change in circumstances in a country of origin. And the classic case here could be something like regime change, right? Could be a situation where people fled from a certain country that was persecuting people on the basis of their religion or their ethnic group or what have you. And that was a specific regime that was in place for a very long time, and then that regime is toppled. And at least in principle, that suggests that that person will no longer have a well-founded fear of persecution in relation to that country. The problem often is that those changes may occur in a way um, that is a seesaw, right? That you may look like there has been a change in the country of origin, and then after a short space of time, instability returns, or there is a resurgence or recurrence of forms of persecution. And this is why the criteria under Article 1C are that the changes of circumstances have to be of a fundamental and durable nature. They have to be substantial, they have to be long lasting, not a temporary improvement. It has to be the case that that safety or that change has to be nationwide, and the burden of proof ultimately falls on the host country and on UNHCR, or UNHCR can help the host country or the state of asylum make that assessment. And refugees should be able to counter that. Again, differently than the other four provisions, where the question really was of activities of the refugees themselves. Here, because this is something external to the refugee should be able to say, well, I do not accept that the circumstances in the country have changed in a way that now makes it safe for me to return. And there is a genuine risk, right? This is something that has arisen in recent years, for instance, in relation to Syria, right? After the Assad regime has been toppled, there have been some European countries that wanted almost immediately to start returning people to Syria. And the claim of organizations like UNHCR was that it would be wrong to act immediately, that you have to see that whatever changes happen is long lasting, is durable, is substantive, right? States may rush, but that rush may mean you've got forced returns before that stability is assured. There are also psychological and social factors that we need to take into account, because people who are survivors of extreme persecution may fear return. And that, in a way, speaks to that subsection of Articles 1C5 and 6, like the idea that the people might have compelling reasons not to return to a place, even if they will no longer suffer persecution. And you need to take those into account. You, of course, should also take into account the length of time that people have spent, and the ramification that that has. And indeed, overall, cessation must be applied cautiously. You have to ensure that return is genuinely safe, and you need to respect overarching or more generally international protection obligations. So this is about Articles 1C5 and 6. And I want to now say a few general things or to talk more generally about how the whole cessation process is to be applied. And I think the starting point for thinking about cessation is the real life implications of cessation, right? So cessation by definition is something that will happen to people who you have previously recognized need protection, right? So by definition, these are people who are convention refugees. It means that at a certain point in time, you have assessed them to have a well-founded fear of persecution for a convention reason. And if a short space of time has passed, then of course they might have not yet created full ties to the community where they now live. But if a long period of time has passed, then of course they might have done that, right? They might have now set foot in those countries. And as we will see after the break, even though there's no hard obligation to naturalize, it is still the case that states are encouraged to integrate a naturalized person. So you can imagine someone who has spent 10, 15, 20 years in a country, has not naturalized in that country, has not been given citizenship of any other country. There has been no change during that period in their country of origin. And then suddenly there's a change right after 20 years. The circumstances of that person now having really established themselves somewhere else, having to pack up and having to go back are quite profound and quite severe, and so they need to happen really um, in circumstances where that assessment is very robust, right? So the first thing that the UNHCR Executive Committee says in conclusion number 69 is that the process has to be fair and has to be clear. And you might say that's something that we should expect more generally in any part of refugee law, but is particularly, I think, um, necessitated in these types of circumstances. And there is here a rebuttable presumption, and that's a very important it's a very important realization, right? So any of the circumstances, and the slide talks about the change of circumstances in the whole country, but it applies also, as we've discussed earlier, to changes in relation to provisions such as Article 1C1 or 2 or 3 or 4. Individuals should be able to rebut the presumption of protection. They should be able to present evidence that suggests, even though it looks on its face that I no longer need protection, there are still good reasons to grant me protection. And there needs to be an individual review of circumstances. So it shouldn't be the case that everyone from a certain country automatically is returned in the same way that it's not the case under the Refugee Convention that everyone from a country is automatically granted refugee state, right? So it's again a mirror image of the idea that refugee status is granted to individuals. There might be many individuals in similar circumstances. That is clear for refugee granting. It's also clear for cessation of refugee status. So that much is true, but the individual assessment is still critical. And there are key risks, right? Which, I mean, to repeat, there is a real risk of premature return. If you force people to return and it turns out that was a mistake, right? So it relates even to the Evitar point about individuals believing they would be protected and end up not being protected. But it's even worse in a sense if it's the state itself imposing return on them when they end up being persecuted. And it's a case where people have already been granted protection. So they have already made often an unsafe journey. They have already been assessed. They need as to their need for protection. And to then reverse that decision, you need it to be done in a way that ensures it's not premature. And there's a real risk also, as I said, of a lack of individual assessment, of blanket cessation decision that may ignore the individual vulnerabilities. And this is very key, right? So what's very important here is the understanding that refugees should be able to mount individual claims on different grounds than their original asylum grounds. So imagine again, the Ukraine case is a good case. Imagine Ukrainians have had their refugee status granted on the basis of many of them having fear of persecution, say people from the occupied parts of Ukraine, right? Where that I think, as we've established, would be an easy case to make. And let's imagine the war now ends, and they are able to return to other parts of Ukraine, potentially. But that person has other grounds on which they would not be willing to return, be it their gender, be it their sexuality, be it their religion, or what have you. You should allow that individual to make a renewed claim. It would be a fresh claim ultimately for protection on different grounds rather than automatically send them away. Right. So that is very important, right? It's very important to realize that cessation comes at a cost to the individual. Cessation means you are upending your life again, ultimately against your will, right? With the exception perhaps of 1C4, where people have voluntarily returned to their country of origin and reestablished themselves. In all the other circumstances, the people are still in the country of asylum, and arguably want to remain there because otherwise they would have returned. And so to force them to return has a big cost to the individual and has a bigger cost still as time passes, right? So it's not the same to seize refugee status after 1 or 2 or 3 years as it is to seize refugee status after 20 years. And there's an arguable human rights case, right, which, as I said, I want to return to perhaps when we talk about the political predicament after the break. There's an arguable human rights case that people should be allowed to naturalize at a certain point in time. That you shouldn't leave people in a continuous limbo where their status can at any point cease, and at that point in time, they become vulnerable to expulsion, and that process can remain 10, 20, 30 years. The idea that people at some point need to be fully welcomed into the political community is, in my view, something human rights law has to develop in the direction of. It hasn't yet, right? As I will demonstrate after the break, and that has serious predicament consequences for refugees. Any questions on any of this, of any elements of the cessation clause? I hope the rationales for why these clauses exist, the way in which they interact with refugee status itself, the risks that are entailed by these provisions, and their application. I hope all of those elements are broadly clear. If they are, then and I don't see any questions, I think what we will do is we will resume in just over 20 minutes, so resume at past. And then we'll start talking about the predicament of refugees and about refugee rights. So I will stop the recording at this point, and we um, we're moving now to kind of think about the rights that refugees have or don't as a matter of international refugee law and other regimes in their country of asylum. So the premise, their assumption for the remainder of today is that these are people who are convention refugees, right? So people who've been recognized under the 1951 convention, and at the same time are not ones who enjoy any other status, right? Which would bring that status then in, right? That's why I'm discussing this right after we've analyzed cessation, right? Our assumption here is that the only status they hold in that country is that of a convention refugee. So, with that in mind, I want to suggest the following. So, this is the kind of structure for this segment of our discussion. I want to start by talking about the nature of refugee law. As I said, various times. The fact that it's an unusual migration status, and about three components of what I call the refugee political predicament. The fact that there is no realizable right to return to the country of origin, the fact that there's no general protection abroad by their country of origin, so no diplomatic protection or consular assistance abroad, and the fact that there's no effective political participation in their country of origin's politics. And on that basis, I want to make normative claims around why recognize convention refugees, right? So narrowing my claim to this particular group of people should be treated for the purposes of political rights as if they're citizens of their country of asylum. And I want to explain, and in some ways, this harks back to how we started today, because I want to link this back to the reasons, the paradigm, as it were, of asylum for people under the Refugee Convention. So this protection paradigm and what it entails, at least on my assessment. So I want to start with this idea that convention refugee status is at least potentially, we should see it as indefinite because of the model under which refugee status is held until and unless there is one of the exhaustive list of cessation clauses that apply to them. What that entails is that at the point at which the refugee status is granted to someone, no one knows how long it will need to last, right? So the refugee doesn't know, the state of asylum doesn't know. The only element that it has under its own control is the possibility of offering the refugee its own citizenship. That's the element of the cessation clauses that has a component of discretion by the state itself, that it can influence this outcome. Um, but of course, even in those circumstances, the refugee doesn't have to take up the nationality of the state of asylum, right? There's no obligation, there shouldn't be obligation under international law to take up the nationality of the state of asylum. There might be good reasons for why people don't do that. One such reason is that it is still the case in international law that states are allowed to permit their citizens to only hold one citizenship, right? That's there's a moving target here. There's a trajectory. Increasingly, more and more countries allow or tolerate multiple nationalities. There is increasingly a human rights argument that people should, once they've migrated, be allowed to acquire nationality if it means they can then become full holders of political rights without having to forgo a connection to a country of origin. I mean, the more migration becomes a phenomenon, the more there's pressure in that direction. And there's, of course, some constitutions that mandate toleration of multiple citizenship. But the legal reality is that there are many countries in the world which don't. They do not allow people to acquire another nationality voluntarily without forgoing their country of origin's nationality. And you can easily think about, a refugee who still believes they would want to return to their country of origin and would thus therefore want to maintain that legal link to that country, and that may prevent them from taking up, even if an offer is made to them of taking up of being granted the citizenship of the state of asylum, they may still decide not to take it, right? So there is a very conceivable scenario. So ultimately, refugee law pertains to three types of what we call in the jargon durable solutions. One durable solution is voluntary repatriation, right? That resolves the refugee challenge because they are no longer the responsibility then of the state of asylum. They become the responsibility back of their state of origin, and that brings the refugee predicament to an end. But that is something that may or may not happen in the refugee's lifetime. We don't know, right? That's the reality. Somebody might have left the Islamic Republic of Iran in 1979 thinking they'll be back after 2 or 3 years and still find themselves somewhere else 47 years later, right? So um, equally, some people left, as I say, left Syria um, during Bashar al-Assad's kind of last years and might be able to return, right? So these circumstances are very dynamic and very individual, very contextual. Um, but that's in some way remains for UNHCR the gold standard of refugee solutions or durable solutions because it allows people to re-enter their own society, right? On the assumption refugees, by definition, did not want to leave, right? They were forced to leave. It's a forced form of migration. They very well may want to exercise the right to return when it is possible to do so, and I'll come in a few minutes to why that's a relevant factor in considering their predicament. So that's the first durable solution. The second is somebody initially enters one country. Often it would be, as we know, a global south country, a neighboring country to the country of origin. And then they get, through a UNHCR sponsored or other sponsored program, resettled somewhere else with the promise that that comes with a form of integration and naturalization. Ultimately, this is a very small scale type scenario, so it's not that we shouldn't consider it a durable solution. It's in some ways a very desirable durable solution if it entails people quite quickly integrating into another society, but it's small scale, right? So the actual numbers of people who fall into this category is limited. And then the third is again, the literature in UNHCR call local integration. So the idea that ultimately a code for being allowed to fully integrate politically into the state to the point of naturalization, right? So those are the durable solution. Anything other than those, and you can say two and three, two collapses into three or three collapses into two because they lead to the same outcome. Ultimately, if neither thing happens, if either the refugee doesn't return to their country of origin or they don't get settled properly in another state, if we're in a position between those two situations, that is, the refugee is in the country of asylum without another effective nationality and without the ability to return, that situation can be potentially indefinite, right? So when you grant somebody refugee status, you can't say refugee status is for 3 years or for 5 years or for 10 years. There's simply no basis for that claim to be made because refugee status will last as long as the conditions that bring it about under the Refugee Convention last, and that is something that is unknown at the time of granting refugee status. Right, so that's the premise. That's the starting premise. I don't know what this is. So I mentioned earlier that countries are encouraged to offer refugees to naturalize, right? That corresponds to Article 34 of the Refugee Convention, which says the contracting state shall, as far as possible, facilitate the assimilation and naturalization of refugees. And it actually goes on to say they shall, as far as possible, um, expedite naturalization proceedings. So and make them less costly, right? So in fact, when states undertake moves like the UK is just about to do, which lengthen the period that refugees have to wait until they can apply for asylum, or when the costs that are entailed by applying for naturalization are very expensive, are very high. Those are arguably against the language of Article 34, but the overall requirement of Article 34 is to make an effort, but if a state generally, for instance, has a policy that is very much not welcoming new people into the political community, they generally make it hard for people to naturalize. Switzerland's a good example, right? It's just very difficult to become a Swiss citizen. Then you might say there is no special obligation in relation to refugees that trumps it, at least not under the Refugee Convention. And so you might find yourself again in a situation where you live as a refugee in a country for a very long period of time, and there's no obligation on that state to naturalize you. So that's again another dimension of the predicament. And so from this follow three specific predicament of refugees that I argue are relevant for our analysis. The first is, and that distinguish, I should say, refugees from other migrants, right? So the first thing is that refugees have no realizable right to return to their country, right? So if we think about it, I mean, we've been spending the last week thinking about situations where people do not want to return, right? But the flip side of this is that the question whether people are allowed to or have a right to return to their country. And here, the overall premise of international law, not refugee law in this case, is that individuals have a right to return to their country of nationality and arguably to their country of permanent residence. That's the Human Rights Committee's interpretation of this provision of the ICCPR in Article 12.4, which is no one shall be arbitrarily deprived of the right to enter their own country. Now, the rationale for that more generally is very clear that, say, someone only has the nationality of one country, if that country wouldn't take them back, it means another country of which they're not a national is forced to tolerate their presence, even if their presence is no longer welcome, right? So, from an international perspective, that is an undesirable outcome. International law warns people. There's a whole concept of the ordering mechanism of international law that people are slotted into their states, right? So, and it used to be the case that that was a ground for wanting people to only have one nationality because it complicates things for someone to be the responsibility of more than one country. But at the very least, when somebody has a country of nationality, there is somewhere to which that person can be sent if you no longer want them to stay. But for refugees, that's not the case, right? So refugees can't be sent back to their country of origin, nor can they return. I mean, they can return in the sense that they're not going to be prevented from returning, but they can't return in a substantive sense because they are refugees. They have a well-funded fear of persecution in that country, so they can't go there, right? And that's fundamentally different than other groups of migrants, right? It's different than work migrants, it's different than student, it's different than family migration, it's different than tourists, right? It's different than any other category of non-forced or quote unquote voluntary migrants are able, at least in principle, to exercise the right to return. Of course, there are periods where that might be complicated for travel reasons, etc. And I don't need to make that point in this call in this context, but because I'm sure it's clear. But the overall premise is that citizens of a country have a right, in fact, an unqualified right to return to that country. There have been some challenges to that practice during the COVID pandemic, where some countries have temporarily limited the number of their citizens living abroad being able to return, most notably Australia and New Zealand for certain periods. That was well, that caused a great uproar, I think, from a human rights law perspective, and it's not at all clear that was defensible from those perspectives. Again, because of the imposition of harm, as you were onto other states by having to tolerate the presence of people. Some people were in other places on short-term visas and needed to return and couldn't return. So this was a test that, in a way, my overarching statement has been stress tested in the pandemic, and on rare occasions, the general maxim that citizens are allowed to return has been proven to be not fully complied with. Overall, however, the premise remains. So in international law, individuals have a right to return to their country, and refugees have a right to return to their country, but they can't realize it, right? So that's the first element of the refugee predicament. The second element is, and I should say, refugees' inability to return to their country and to use indeed that country's travel documents does not translate to individuals being entirely landlocked, right, in their country of asylum. So there was recognition that ultimately refugees are differently situated than other individuals, than other migrants, than the citizens of the country itself that grants them asylum, because everybody else has a right to travel abroad on the promise and premise that if they travel somewhere else, they'd be able to return to their country of origin, right? A refugee, say you've got a refugee from Eritrea who's been granted refugee status in Germany, they want to travel to France, right? Um, how would they do this? They can't use their Eritrean passport. They shouldn't be using their Eritrean passport, nor should they be landlocked in Germany. And that differentiates them from any other migrants in Germany who would be able to travel from Germany to France using their country of origin's passport. And so the solution the Refugee Convention found for this unusual predicament is to require contracting states, as you see on your screen, to issue to refugees who are lawfully staying in their territories travel documents for the purpose of travel outside their territory. And the only reason not to do this is if there are any compelling reasons of national security or public order that prevent this. So the premise of the Refugee Convention was refugees should not be limited in their freedom of movement, nor not within the state, as we'll see a bit later, nor outside the state. They should be able to live a full life in the country of asylum in the same way you would expect citizens to be able to in respect of their own country. And in order to facilitate that, they're issued with something that no other migrants is issued with, right? That's part of my premise for my argument of thinking about refugees as differently situated than other migrants. No other migrants needs a travel document issued by their country of residence because they have a travel document of their country of origin, which they can use. And the usage of that document would not have any effect on their legal status. Whereas if a refugee, as we saw before the break, would use their travel document to travel to another country, sorry, would use their country of origins document to travel to another country, that might be seen as a ground to seize a refugee status, right? Because it would be seen as a sign of being willing to obtain the protection of their country of origin, and that's something refugees are by definition not able to do. So that to me is an indication. The refugee drafters, the Refugee Convention drafters understood there's a specific protection gap for refugees compared to any other migrant, which necessitates a specific bespoke solution. And that the solution was the issuance of a convention travel document. And the corollary of this travel document is the instruction to states to undertake that the holder of that travel document shall be readmitted to its territory at any time during the period of its validity. Right? So the premise of a passport, again, I've made this point in a previous seminar, is you allow someone else into your territory holding a certain passport on the assumption, on the mutual understanding that if that person were to be no longer desired, they could be returned to their country of origin, and that country would have to accept them based on the fact that they hold the nationality of that country. For refugees, their country of origin is not relevant. So the country that steps into that role is the country of asylum. And so if you are a Eritrean living in Germany, you would be issued by Germany with a travel document that says you can travel to France or you can travel to Canada or you can travel to Israel. And um, if that country didn't want you to stay longer or you travel to that country for a week or 2 weeks, that country knows that Germany would have to accept you back because the holder of that document will be readmitted at any time during the period of its validity. And that's quite significant. That essentially equates the status for the purposes of travel outside the territory of a refugee to that of the national of that state, right? That is the difference, right? So if you hold a student visa in Germany and you travel on your Paraguayan passport to Norway, Norway can only know that it can send you back to Paraguay, but not to Germany, right? Germany may or may not have an obligation towards you. It depends on the terms of the visa. The visa expires, they may not renew it. Right here, as long as the person has refugee status, they need to hold a valid travel document. Um, the travel document should correspond to the period. Travel documents may be issued for fixed periods, right? Because that's the nature of documents, but they have to be renewed as long as the person remains a refugee, right? So that's a very critical, in my view, in my assessment, a very critical indication in the convention that refugees were deemed to have particular needs that other migrants don't, and they had to be addressed. So that's the first element. The second element, which the convention doesn't address, and international law has moved in the direction of recognizing, but not yet fully addressing, is the very obvious predicament of a refugee, and that is that the model under international law is that when you travel to another country, and if something happens to you in that country, then your country of origin should be able to make diplomatic representations on your behalf. So, as I'm sure you'll be familiar, there are sometimes cases of people traveling, including, say, from Israel to Thailand or other countries in East Asia, and being arrested for a drug offense or otherwise. And the Israeli embassy or consulate would step in, would try and visit them, would try and pass them information, try to connect them to a lawyer, try to get them to leave. And that's normal practice, right? So there's a series of case law about people who were Mexican nationals who, in various contexts, were caught in the United States, and the U.S. would not allow them access to their consulate, and that was deemed by the International Court of Justice to breach the obligations of the U.S. under the laws around diplomatic protection and consular assistance. Now, refugees, by definition, cannot do this in relation to their country of origin, right? As we've discussed before the break, if an Eritrean refugee got caught in Norway, having supposedly committed an offense, they couldn't ask the Eritrean embassy for help because if they did, they would be reavailing themselves of the protection of Eritrea. So what happens? They have no other nationality. As international law stands, if they turned to Germany and they said, "You've given me refugee status, can you help?" At least as a matter of general public international law, the answer is no. The answer at the moment is only countries of nationality can intervene on behalf of their nationals, and they can't, by the way, intervene on behalf of their nationals in another country of which the person has a nationality. So if someone has, say, Israeli and American nationalities, and the Israeli embassy can't intervene on their behalf in the United States because they have both nationalities. But that's for refugees, that's they're faced with the opposite problem, right? That no one can step in to help them. And there's a really interesting contrast here. So think about the Migrant Workers Convention, or in its full name, the International Covenant, the International, sorry, Convention on the Rights of Migrant Workers and Members of Their Family, a less known convention, not so widely ratified, but indicates, because it's a relatively recent convention, um, indicates the kind of direction of travel in terms of rights protection. It says explicitly migrant workers and members of their family shall have the right to have recourse to the protection and assistance of the consular or diplomatic authorities of their state of origin. So if you're a migrant worker from the Philippines and you're mistreated in the UAE, then then the Philippines then the UAE must give you recourse to the Philippine embassy, and the Philippine embassy must be allowed to see you and assist you. Right? So that's the contrast. So, how does international law seek to, at the moment, address this predicament? So, the draft articles on diplomatic protection issued by the International Commission just under 2 decades ago. These are draft articles. They've been adopted by the General Assembly in a resolution, but it's not a binding document internationally. So it's a direction of travel, as I suggest. Says the following. It says a state may exercise, may, doesn't have to, but that's true about diplomatic protection more generally. States have the right to exercise diplomatic protection under international law. They're not obliged to. So states may exercise diplomatic protection in respect of a person who is recognized as a refugee by that state in accordance with internationally accepted standards, provided that person at the date of the injury and at the date of the official presentation of the claim is lawfully and habitually resident in that state. In other words, in my scenario of an Eritrean refugee in Germany finding themselves in trouble in Norway, if the Eritrean had lived in Germany as a habitual resident, right, and only traveled to Norway temporarily when the injury happened in Norway, and 2 months later, they seek protection from the German embassy, and they're still deemed to have that connection to Germany. Then Germany would be able to act on their behalf, even though they don't hold German nationality. And even though Germany wouldn't be able to do the same thing if a student studying in Germany got caught in a similar problem in Norway, right? And that recognizes, again, from an international perspective, that refugees are different, that they have a specific protection need vis-a-vis a state, right? A guardian angel of sort, that their state of origin is simply unable to provide. So that's and the commentary to the draft article says it recognizes that this is an exercise in progressive development of the law. So for those of you who know international law, you will know that international law involves a dual process of codification and of progressive development, right? So you codify rules that already exist, and you codify them in a document, in a convention or otherwise, or you try to progress international law in a certain direction. So this falls under the latter very clearly because historically diplomatic protection could only be exercised on behalf of your nationals. This was a realization, I think, very welcome one by the International Law Commission that a human rights approach to the application of rules around diplomatic protection necessitates thinking about refugees in the same way you think about nationals and not in the way you think about other migrants, right? So that's the second kind of type of predicament that has there is at least a direction of travel that suggests it might get addressed. And then we come to the main predicament that I've addressed in my writing, which is around political rights and in particular around electoral rights. And here the challenge is that refugees, again, by definition, being outside their country of origin, not being able to return to it to participate in its electoral processes, not being able ordinarily to contact the embassy, even if that country allows people to vote from abroad, which some countries do and others don't. Even if the country does, it ordinarily requires contact with the official sources of that state, right? The embassy or the consulate often would require physical presence in those spaces. And that's simply something refugees in the main are unable or unwilling or both to do, right? And again, the comparison here to the Migrant Workers Convention is very instructive because the Migrant Workers Convention says that migrant workers and members of their family should have the right to participate in public affairs of their state of origin and to vote and to be elected at elections of that state, right? So it says very explicitly, actually, if you're a migrant worker outside your country, you remain a full citizen of that country, and that includes the right to vote and to be elected. Say, not all countries allow that, but countries that are signatories to the Migrant Workers Convention generally do. And increasingly, more and more countries, in fact, a large majority of countries in the world do allow it, right? And so, again, the comparison with refugees is very instructive. And the interesting dimension here is the realization for refugee participation of the relevance of participation in elections of your country of origin as part of the process of reintegration into that society after a change, after a fundamental change has occurred, um, like in a context of post-conflict or transformative elections. And here, a good example that I use in my book as well is the Dayton Accords, which I imagine most of you are too young to have lived when they were signed. So these were the accords that were signed to end the war in Bosnia-Herzegovina as part of the sequence of wars in the Balkans in the 1990s. And one of the things that happened, amongst many other terrible things that happened during that conflict, was that very large numbers of people were displaced from their homes during that conflict. Many outside Bosnia, some internally displaced, but very many were not able to be present in their place of ordinary residence. And as part of the Dayton Accord, the annex to the Dayton Accord said the exercise of a refugee's right to vote shall be interpreted as confirmation of his or her intention to return to Bosnia and Herzegovina. More so, there was an obligation under the Dayton Accords to facilitate the return in order to participate in elections. People should have been allowed to return and vote where they previously have resided. And in some instances, people voted from abroad, but that vote was deemed as an indication that there is a presumption or a resumption, rather, and presumption of protection in a way that is meaningful for their participation. And again, this is very different in situations where a conflict is ongoing or where there's no conflict, where people get refugee status in the classic situations that we've discussed in previous days, like a situation where there are political dissidents and they're being persecuted by the regime, or a situation where they're part of a minority that is being persecuted or otherwise, right? So there's a big difference here, right? The difference here is that for post-conflict situation, the underlying assumption is that the conflict has ended or is likely to be resolved soon, and so repatriation is either imminent or forthcoming. For most refugees, most of the time, that is not the premise, and I say this in factually because that is the case. Because the case is that the vast majority of global refugees are in what we call protracted refugee situations, which means that they are living somewhere outside their country for at least 5 years. That's how UNHCR defines protracted refugee status, and that's more than three-quarters of the world's refugees, right? So most refugees are in a position where there would be an election cycle in their country of origin in which they couldn't participate. And in fact, some countries, like say the Republic of South Africa, in its asylum legislation, says explicitly that participation of refugees in elections of their country of origin would be a ground for cessation of their refugee status, right? So we've got a clear case where refugees can't participate effectively in the country of origin. Now you might say, well, there are also some countries in the world where generally there are no elections. So why would that necessarily entail an obligation on the state of asylum? And this is what I'm coming to next, right? So so before I come to that, the positive law bit. The positive law bit is that the 51 Convention says absolutely nothing about the right to vote. Indeed, it says nothing about political rights. Um, we'll come in a few minutes to the rights that are protected in the Refugee Convention, and you will see some of them are civil, most of them are socioeconomic, but none of them are political. So the Refugee Convention didn't speak to political rights. The other international human rights instruments do. So the Covenant on Civil and Political Rights does protect individual political rights, including of migrants, but not the right to vote of migrants. So this is the context in which I make my claims. So the relevant provision here is a provision from the Covenant on Civil and Political Rights in Article 25, where the convention says that every citizen should have the right and the opportunity, without any of the distinctions in Article 2 of the convention, to vote in genuine elections, periodic elections rather, by universal suffrage and by secret ballot, etc. But the provision says every citizen. Now, there's nothing in international law that says that if you extend the right beyond citizens, you are breaching international law. I mean, arguably, um, international law would be very comfortable, or the position in international would be that it would be very comfortable if a state were to do this, but it's not required to, right? So it's very clear from the language of the ICPR, there's no requirement to grant the right to vote to any non-citizen. And as I said, the Refugee Convention itself also says nothing about it. So in my book that detailed those different elements, voting rights of refugees, I make the following normative claims around arising from this predicament that I've described. I'm suggesting in the book that recognized convention refugees are a special category of what I call a non-citizen residents. So within the group of residents in a state that are not citizens of that state, most of whom are migrants of other categories, right? Work migrants, students, and others. Refugees are migrants, but they are a special category of non-citizen residents. And the reason they're a special category is what they need is full membership in a political community for an indeterminate period of time, by which I mean the gold standard would be for them to either be able to return, in which case they resume their full membership of their country of origin's political community, or they get an effective nationality of another state, uh, potentially the state of asylum, potentially another, in which case they become full members of that state's political community. But until and unless one of those two things happen, it is desirable that they be treated by the country of asylum as if they were its nationals. And this is to be done. And this, I'm sorry for the rather clumsy framing here, but the way I couch it is to say through the temporary disaggregation of rights that are otherwise accepted as citizenship dependent in international law. And now, in plainer English, it's if you've got a state that says that only citizens can vote, that is something states are allowed to do in international law. States can't say only citizens are protected from torture or only citizens have the right to freedom of association or expression because those rights are granted to everyone, but they can in relation to citizenship rights, like the right to vote. And so my claim is that even if states are generally permitted to have a restriction on voting rights to citizens, they should allow refugees to vote as if they were citizens. And that is the fundamental meaning of recognition of refugee status. That someone, and it relates to the discussion we had with Aviatar before the break, that the condemnation of the practices of another state is having denied an individual essentially their equal and full stake as a member of that state's political community, essentially forcing them out, not enabling them to live in that country in a way that is required, a failure of that state's to exercise its duties. The recognition of that person as a refugee comes with political remedies for that political predicament. And what I argue fundamentally is that that is desirable also from a policy perspective. It's desirable from a policy perspective because it makes it more likely for refugees that refugees would want to integrate into a political community if they feel they have a stake in that community. Makes it more likely that the community, people around them, would see them as equals in that community. It makes more likely the case that their interests would be protected properly because they are voters. And we know in elections, the people who vote are the people you listen to, and not necessarily the people who can't vote, who live within your midst. So there are good policy reasons to do it. ultimately the argument in the book and the argument I'm making here is not an argument, unlike many of the things we've discussed in previous days, is not an argument that this is the correct interpretation of the Refugee Convention, because I'm not suggesting the Refugee Convention requires it, or indeed even that human rights law more generally requires it. I'm suggesting that that should be the direction of travel of international human rights and refugee law. In my position, I mean, not that it helps much in the realpolitik, but has broadly been accepted by UNHCR. It's been accepted also by organizations like IDEA, so the International Democracy and Electoral Assistance, in a report that they published a few years ago. But it is not the practice of states. And so there are only four countries in the world that generally allow non-citizens, all non-citizens, to vote in all of their elections, and full countries, right? And three of them only allow it after a very lengthy period of time. So the only example of a country that does it in a short space of time that I would deem to be compatible with my model is New Zealand, Scotland, and Wales, in the United Kingdom as separate devolved administrations have have extended the right to vote in their elections, the regional elections, ultimately to the devolved power, devolved administrations, to any resident, and that includes refugees, even includes asylum seekers. But that's not national elections; those are regional elections. So there's a big gap between what I would want international law to move to and where state practice currently lies. But I thought, given the overall context of the course, that it would be helpful to use my argument as a way of illustrating why I think refugees are different than other migrants, because there's often also an attempt, often by very well-meaning people, to collapse all categories of migration into one, and I maybe not as a form of turf war, but as a form of I think being true to form. I do not accept that. I think there are relevant differences between forced and other types of migration, and in particular ones that pertain to political membership. And I think that's the angle I wanted to highlight. So there was a long kind of monologue for me. So I'm going to pause and see if there are any questions or comments, clarifications on this, and after which we're going to have a short just getting up from your chair break before we move to the last part. So any challenges to
think
this?
I think
Any?
that maybe the issue was that a lot of the countries I think we saw in the first seminar, maybe or the second one, where a lot of refugees actually are
Mm,
places with limited political rights in general.
mm,
So that would make this
mm.
difficult to implement. Like I think we said Iran had a lot of Afghani refugees.
That's right.
So I think, I mean, it makes a lot of sense, but it only makes sense if we assume that those states indeed have, representative governments.
Sure. So I take that point fully. I mean, uh, by definition, if a country doesn't uphold the rights that its own citizens and indeed rights that are not restricted to citizens that it's supposed to maintain under human rights law, then it's very unlikely any form of extension will happen, right? So I would argue a country like Iran doesn't respect other political rights that any person, not just citizens, have, right? So rights that refugees should already enjoy, like the right to freedom of association or the right to freedom of expression. And so you are right that obviously any model that expects states to extend electoral rights in the way that is described in the ICCPR presupposes those states have elections of that nature. So yeah, so that type of critique or challenge is right. And you also, I think I suppose to strengthen your point, um I also accept that that obviously is not a moot point, right? It's relevant to quite a few of the world's refugees who do live in countries where they might have their socioeconomic rights protected, but they won't have their political rights protected. That is true. I don't know if it's the majority of the world's refugees, because even though the majority of the world's refugees live in um, the global south and in neighboring countries, the countries of origin, many of these countries do have electoral processes. We might say those are not exactly producing wonderful results, but countries, for instance, in sub-Saharan Africa, there was just a recent election in Uganda. Museveni won his, I don't know, eighth or ninth term, so we might debate whether that's so great or not. But there are electoral processes in quite a lot of refugee hosting countries. But your point is well taken.
And also you're talking about people that have obtained refugee status, not like the asylum seekers.
Well, my framework starts from the premise of recognition because only after recognition do you have the other elements that follow, right? The fact that you can't engage with your country of origin, the fact that the cessation of refugee status are the only conditions under which your status comes to an end, the fact that you need to have a convention travel document. So all of the other legal frameworks follow from recognition. I do accept that, by the way, and this has been a challenge to me in the past, that some of the things that I talk about may apply to other people who get protection who are not convention refugees. So some of these elements apply. I don't think the full framework applies because I don't think the severing of the political ties necessarily applies in, for instance, situations of temporary protection. I don't think necessarily so. So, a country like Ukraine is an interesting example to me. I mean, Ukraine has decided, and it may be a reasonable decision, not to hold elections, essentially ever since the full-scale Russian invasion. And the assumption is you can't do it under the conditions of conflict and war, and you don't want to do it. I mean, that I think is the political choice until and unless Ukraine, the parts that have been occupied, are liberated. But let's say Ukraine did manage to hold elections, decided nevertheless to hold elections, even under situation of conflict. It's not obvious to me that a Ukrainian in Germany can't participate, or that there's anything about their participation in Germany that undermines their temporary protection. In the same way that if they were granted refugee status in Germany because Ukraine had persecuted them, then it would be challenging for them to contact the Ukrainian embassy and be involved in the election, right? So I do think, I mean, obviously I'll defend this because this is the model I've written, but I mean I do accept that it's not that nothing of this applies to other groups. Some of these things also apply to other groups of migrants. You might say some migrants don't really have the effective protection of their country of origin. Some migrants are left loose, right? And the country of origin couldn't care less how they're badly treated. So they may nominally have diplomatic protection rights, but the country of origin exercise it? Never, right? So they're obviously like any model, um, there can be challenges to its application in specific outcomes. The overall framework, I think, works, but as I say, the big challenge it faces is no country, for various policy reasons, which we might surmise, wants to or has gone as far as implementing it. If any, I think the general trajectory, which I regret, but is the reality, is the opposite, right? The general trajectory is that the length of period that refugees have to wait until they become citizens has become longer, and at the same time, they haven't had rights extended to them. So the period during which people remain in this political limbo, in certain countries at least, has increased rather than decreased over the last few years. And as I say, that's a phenomenon that I personally regret, but I think, in the fairness and in the fullness of presentation, I need to acknowledge it, right? It's the political reality of refugee protection we're in. Other points, questions.
So the political rights you think should be considered are full citizenship, meaning that even if their country of origin become perfect, uh, one day they still are citizens.
No, it's precisely not that, right? So
Okay.
that's precisely the argument I'm making, that actually I can understand, although as I say, I think after a certain period of time, maybe 10 years, maybe 15 years, we can debate the exact kind of threshold. I think there's a human rights argument that the balance of interest, between the state and the individual changes so that states should be required to offer citizenship. But I actually argue granting someone the right to vote without granting them citizenship retains the possibility for the state that if something changes in their country of origin and they're able to then seize the refugee status, then they haven't granted that person citizenship. They're not bound to have that person remain permanently in the state. It's just recognizing that for the period in which that person is in the state, they are full members of the community. So it's precisely the argument that I make that it's a less onerous demand of a country of asylum to grant them voting rights than to grant them citizenship. If you grant them citizenship, then by definition, you grant them voting rights because that follows as a matter of international law that citizens should have the right to vote. I'm suggesting that that's actually too strong a remedy for the refugee predicament because there might be refugees who are able to return to their country of origin at a certain point in time. And as long as it's not too long in the future, it might be reasonable for states to say, let's again take the Ukrainian example, right? Um, it might have been reasonable for people to say we're going to give Ukrainian voting rights in German elections, but we don't want to make all Ukrainians immediately German citizens in case things change in the next 5 years and they're able to return to Ukraine,
Yep.
right? So it's a less demanding requirement than citizenship.
I have another sort of another
Sure,
very very strong issue.
sure.
I think. What about the problem of politicians bringing more migrants because they know that if they bring this migrant from this particular era, they will vote for them. They will get citizenship. It won't take it won't be a long process. They will vote for them. That will cause a very problematic incentive to bring more migrants to a
But
certain country, say other than another country.
but the model,
There are allegations right now in the United States that such these things happen, and these at the very least with regular migrants, illegal ones, so could happen
Yeah,
here as well.
but the model here assumes that the people who arrive, firstly, I mean, it's not premised on the idea that someone brings other people, right? It's premised on the idea that people arrive as asylum seekers, right? So
Yeah,
it's not a wider extension of the right to all migrants. That's precisely the point. It's an extension of the right to people who have protection needs, who have arrived on their own volition, right? They're not brought in, right? It's not. I don't think that's a correct framing. Like it's not the case that anyone, even in the case of, if you will, some people say from Central America who ended up crossing the US border, they were not brought in by a political party or by a politician. They have traveled. You might say, which is a more nuanced way of making your point, that if people know that once they arrive,
yeah,
they will get citizenship, that creates an incentive. But that's in a way, that's a legitimate but general challenge to any form of rights protection in a convention respecting state, right? So you can say the more a country respects the rights under the convention, the more it's actually operating in the spirit of the convention, gives people housing and welfare and education, and that the more people would want to come to that country and not to another country where the convention may have been signed, but the rights are effectively.
yeah. No, but I
That's so
don't
that's a
talk about
general point.
I.
That's it.
Yeah,
That's
but
it.
I don't talk about the incentive of the immigrant. I'm talking about the incentive of the people in power, the politicians. That they
Yeah, but
will they if I give welfare to migrants, they may want to come more, but I'm as a country won't let them. Whereas if I have the higher possibility to give them citizenship and the legitimate framework to do it, then I will bring them. I will want, if I know there is a mass area where there is conflict, I will make sure that they will come to my country. I'll be more welcoming to them.
Yeah, sure. But
But
on that basis, there's nothing stopping those politicians from granting those people citizenship. That's already a possibility. It's already
yeah, but
discussed.
they have a harder time maybe politically to legitimize it, being legitimize it because there
Well, I
is
mean,
no.
look, the question what one has harder time politically legitimizing. I mean, if you're right, and if that fear exists, then they would have a hard time legitimizing the extension of voting rights as well, right? So on the same logic, right? Because it's
No, but we are doing. But this is not about the decision of the country. This is about the decision of the, refugee. What do you say? The
no,
general
no,
United Nations refugee
no,
law,
but
not
no,
a specific country.
but a state would have to accept it, right? It would have to sign on to this. This is not existing refugee law. So you're saying if a state has accepted this, and a state, in the same way, if the state had accepted that it needs to grant citizenship to refugees after 5 years, that also has implications in the same way, right? So imagine if the convention had required that after 5 years, all refugees, if they have not returned, have to be granted citizenship. It could have
Hmm.
said, right? If it said that, that creates a similar incentive, right? So you can have a conflict region, and if you remain in power for 5 years. So I think there's a deeper point here, which is there's the functional states should have a degree of trust that a specific government doesn't alter the rules in order to better its
Oh,
political position. When you're not in that position, then your problem isn't the refugees. Your problem is your own political system. So it's
yeah, well,
but I don't want to get into that political discussion. I think we all we all can think about what examples we have in mind. But that to me is the fundamental answer. Like, I don't think, to me, the fact that a system can be abused by an actor internally shouldn't be a reason to deny rights. If you accept those rights should be granted, right? So I think there's a big debate. It's an understandable debate as to whether you should not move into that space um, where you extend voting rights beyond citizens in national elections. I think there are respected arguments to that effect. But I don't think an argument that, I mean, to me, the argument around internal misuse is not, it's not persuasive in my view, but I respect that other people would take a different view. Um, okay, we've talked our way out of, I think, uh, a short break at the moment. Unless, so yeah, unless if people have to jump off, I think by all means jump off. But I also don't want to keep you obviously beyond the time. And I did want to talk about this at least briefly. So let me try and do this in the next 15 or 20 minutes to just talk about that relations between rights in refugee law and human rights. So if you do have to step off, please do. And obviously there's a recording. But I think that's probably better than to now take a short break. Um, so this is the stuff that I want to kind of talk about relatively briefly. I want to talk about the fact that the 51 Convention has different categories of rights that are based on two axes of protection. One is the degree of attachment to the state of asylum, and the other is the degree of protection that people enjoy in the state of asylum. And the history of this, as I've intimated at the start of today, is that in the past, the Refugee Convention preceded human rights treaties. And so there was historically, before human rights treaties have extended rights as a general matter, the position in historically in agreements between states was that often there was a model of reciprocity. So often the model was you've got a national of country X in country Y, then as long as country Y gives rights to nationals of country X in a certain area, country X is going to give rights to nationals of country Y in its territory, right? So you've got Germany and France. German nationals in France would have a right to work if French nationals in Germany would have the right to work, but there wouldn't be a general right to work of non-citizens, right? That used to be the history, and that was the context against which the Refugee Convention was drafted. It wasn't drafted against the notion that there is universality of rights to a level where the presumption is that every right is guaranteed to everyone within your territory, except for those that are explicitly excluded, like the right to vote, where there's a specific designation around citizenship. The presumption was a different one, and that's the context in which this treaty was written. So those two axes, the degree of protection and degree of attachment, taken together, create what Jim Hathaway has called a system of dual contingencies on certain refugees' rights. And what I mean by this is the following two tables. So we don't have to go into the specific individual examples, but I just want to illustrate table one, which says if you read the text of the convention, which I implore you to do, I think it's not a long treaty, and it makes much more sense to understand refugee law once you have actually read the treaty cover to cover. So I would suggest perhaps over the weekend before the next class, if you do that, I think that would be a very good thing, even if you haven't read other things, which I appreciate because of the intensity of the course. You might end up reading them when you work on the assignment rather than now. I appreciate that, but I think the convention itself you should try and read, and indeed the handbook of UNHCR I would recommend reading as well in full. So the main thing here is that you look at this table and you see five different stipulations in the convention. Um, Four of them relate to the type of physical presence that the refugee has in the country of asylum. So one is physical presence itself. The second is lawful presence. The third is lawful stay, excuse me. And then the fourth is habitual residence. And these are an incremental scale. So the assumption here is that on day one of having entered a state physically, you don't, for instance, have the right to housing, right? That comes when you're lawfully staying in the state, or the right to have public relief, or even the right of association. That comes only later, right? So that's how the convention framed it in terms of the degree of attachment. And it also designated certain rights as rights where the level of protection that individuals would receive would not be the level of protection that nationals have, but the level of protection that other people have were migrants. So usually the most favorite migrant status, right? So the status, the best status that other migrants have. But you can see that relates to rights like housing, like secondary education. So primary education is guaranteed to refugees at the level of citizens, but others at a lower level ultimately, wage employment, self-employment, and others. And so if you take those two tables together, you can see that there is this dual contingency system. So if we take the harshest kind of combination, you can see that the standard for treatment in relation to being engaged in liberal professions, right? So saying being a lawyer, you would need to be lawfully staying in the state, and you would only get it to the extent other migrants have that right. So not equivalent to nationals, but equivalent to other aliens. And similarly, you can look at the other side of the table, various rights around artistic and industrial property, right? And so this whole model is quite a weird model because it's also very at least to me, and I've spoken to various people about this, and to them as well, it's very unclear why certain rights were put in which category, right? So why self-employment, for instance, a right that entails very little obligation on the part of the state. It's just a right to facilitate someone working, not being employed by an existing business in the state, but just opening their own business. Why should that be contingent on lawful presence rather than just physical presence? Or why should public relief be left to lawful stay? So um, it's not entirely clear. The overall framework, you might say that the more rights require financial assistance, they tend to be later on in the refugee state. But similarly, or conversely, rather, you can say that there's an obligation to provide elementary education or primary school education, which is, of course, costly. And that's an obligation that you have to provide immediately as the refugee comes within your jurisdiction and at the level that is provided to nationals. So to try and make any sense of the specific designation, I think is quite a challenging effort. There's a really good paper by Marina Sharp that kind of goes into the internal logic of this framework. It's on the reading list, I think, so I recommend looking at it. But what I want to do, rather than do this kind of individualized, painstaking assessment, is to think about how this sits now alongside the fact that we do have a human rights framework, right? And Article 5 of the convention, which I think I mentioned in the first seminar, said that nothing shall be deemed in the convention to impair any rights and benefits that are granted by contracting states to refugees apart from this convention, right? That was an anticipatory kind of type of provision that essentially said we know as things develop, it is likely to be the case that there would be human rights treaties, and we don't want the Refugee Convention to become a ceiling. We want it to remain a floor. We want it to be the basis or the basic level of protection that refugees should have. But should in future refugees enjoy greater scope of protection, states should not be allowed to fall back on the Refugee Convention and say, the Refugee Convention says, I don't have to grant you this right until you're in the country for a certain number of years, and so I'll delay that if human rights law requires them to do otherwise. And the context for this is the provision in covenants such as the Covenant on Civil and Political Rights, which says that every state undertakes to respect and to ensure respect to all individuals within its territory and subject to its jurisdiction. And that provision applies to all rights except specifically the right to enter the country, which, as we saw earlier, is the right is limited to those whose own country we refer to, citizens and potentially permanent residents. And secondly, the right to vote. But any other rights under the ICCPR is granted to everyone. And the language the convention uses is everyone. It says everyone shall have the right to freedom of expression. Everyone should have the right, freedom of association, etc. Those rights, of course, can be qualified. So they're not absolute rights. They may be limited. They may be limited for nationals. They may be limited for migrants. But the provision of those rights is not contingent on you being a national, right? And so refugees are within the scope of this provision because they are individuals within the territory and subject to the jurisdiction of the state. And so they enjoy those rights. And they enjoy essentially a protection from discrimination, right? So the same convention, Article 26 of the ICCPR says, all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. And that's both formal equality, so equality before the law, and it's also substantive equality, so the equal protection of the law. And what Jason Pobjoy has translated this is, the question that arises to which Jason Pobjoy is responding is, what is the relations ultimately between the fact that we've got the ICCPR saying there is an equality guarantee between nationals and non-nationals, including refugees, and the fact that we've got these dual contingency system in the Refugee Convention? And the answer that he gives to that is you were supposed to ask three questions around discrimination. Has there been any differential treatment between individuals in similar circumstances? So is there an inequality basis for a discrimination claim? Is the unequal treatment on a ground that's captured by the provision, so including nationality? And can you justify that unequal treatment on reasonable and objective criteria? If the answer is yes, then there might be circumstances where you would say it's justified that nationals get certain benefits, for instance, certain housing benefits, that refugees and other migrants don't. You might say refugees have a right under the convention to provision of housing, but not at the same level as nationals, given nationals contribute through intergenerationally to the taxation system and the building of houses. I'm not saying that's my position. I'm saying you could try to make that position and make it compatible with the refugee definition. Similarly, around other things like secondary or tertiary education, even more so. You might say I'm providing nationals with free university tuition, but not migrants, and to that effect, also not refugees, right? So it doesn't mean the ICCPR doesn't mean that on every single element, the treatment of nationals and non-nationals, including refugees, has to be identical. But it does mean that there is a presumption of equality in treatment, and where that presumption is rebutted, there needs to be a justification for why there's differential treatment. And so the final thing I want to say, and then I'll stop, is this question of why do we need then the Refugee Convention at all? Should we even pay attention to the rights to all that section of the Refugee Convention that I've just suggested that you should try and read between Articles 3 and 31? I mean, should we just skip it because refugee law is not relevant? We've got general human rights law. And the answer to this is that there are certain things that the Refugee Convention grants refugees that actually human rights law doesn't specifically speak to. And the most obvious of those, so I don't want to get into the details of this. I'm happy to, if people email me if they want to, if you read those and they raise questions for you, I'm happy to get to that. But the most obvious of those is the travel document, right? Which for good reason human rights law doesn't generally guarantee migrants the right to have a travel document issued by their country of residence because they don't need one for the reasons that are articulated. But refugees do need one, which is why the Refugee Convention requires states that grant them asylum to issue those travel documents. So that's an example of where actually refugee law supplements or complements general international human rights law. And even though general international human rights law is subsequent, is later, is more elaborate, is more protective generally, it's not conclusive, it's not comprehensive, and there are certain elements that one needs to add to international human rights law, and some of those elements come from refugee law. So this was a bit of a fast tour around rights, given our timing and given I'm sure you're at least as exhausted as I am. And this has been 5 sessions. So well done to all of you, right? You've gone through that. That's I don't know if it's torture or inhuman or degrading treatment, but it might come close to that. So I'm very grateful to those of you who were able to attend. I know it also was difficult, and some of you couldn't attend everything. But yeah, we've gone through this week, and we only have one. Given I've covered the areas that I wanted to cover, we won't meet on Thursday next week. So I said I will tell you at this point. In the course whether that session is needed, so you can strike it off your calendars. And we will meet, of course, on Monday, where we have Shachar, who is going to be speaking to us about asylum seekers in Israel. So it will be a bit of a discussion between us, but she, I think, will start off with a presentation, and I hope you will engage now that you are equipped with quite a lot of knowledge around refugee law. The application of that to the situation in Israel, I think, will be much more meaningful, and obviously something that's close to home, literally for you, and so hopefully will be of great interest. Notice that the time is different because it's the eve of Remembrance Day in Israel, and so We are starting at 1 o'clock Israel time on Monday, and we are running for 3 hours. So 1 to 4, we'll take a break at the relevant point in time, which Shachar and yourselves would be happy with. So any final questions for today or comments for today?
I'm not entirely sure I'll be able to attend the full session on Monday because I have a course and the times are different, unfortunately. But
Sure.
I'll try the best I can. It sounds really interesting.
Okay, phenomenal. Great. And of course, I will send, so I will also talk a little bit about the assessment on Monday, but I, of course, realize not everybody's able to attend. Of course, the information will be on Moodle. I'll send an announcement in the usual way. And of course, you can email me and I'll pick up your email if anything arises. It won't be anything too cumbersome, so I wouldn't be worried. Great. Okay. So I shall leave you at peace at this stage. Wish you a very, very good weekend, hopefully a quiet one. And I will see you on Monday.
Thank you very
Thank you
much.
so